Okay, Assalamu alaikum everyone. Thank you very much for joining this talk. The topic is the importance of succession planning. Can you all hear me clearly? The topic is the importance of succession planning, wills, probate, inheritance. This is a topic nobody wants to talk about. But if I ask you, do you know anyone passed away? You put your hands up, say yes. Was there any problems with inheritance, with the family disputes, with the claiming the money, finding the money? Everyone say yes. But when it comes to talking about this subject, everybody just want to ignore it. So I'm here to talk to you about the subject in detail from an Islamic perspective and a conventional perspective. Now, I just want to say one thing to everyone. Because of the law of the country allow you to take something, it doesn't necessarily mean Islamically it belongs to you. I'll say that again. If the law of the country allows you to take something, it doesn't mean Islamically it's yours. This is why it's important you talk about this matter, you get the right documents, and more important, you make a list of assets. Now, for me, the best type of will is when you sit down with your family and tell them, this is what I want, this is how I want things to work. For me, this is the best type of will. But unfortunately, people don't want to talk about the subject. This is why the family is always fighting. The reason why I put a disclaimer, I don't want to upset anyone. It's a very touchy subject. Have you ever noticed when you go to a graveyard, you see more men dead than women? Yeah? It's a fact. You go to a graveyard, you see one woman, about 50 men. If you look at probability, the life expectancy of a male is less of a female. If you look at insurance companies, they charge more money for life insurance for the male than the female, because according to their records, the man will pass away faster. It's a fact of life. There are less men in this world than women. This is another argument or debate when people say if there's more women than men, then the men should marry more because the women can't find a husband. I agree with it, but that's a different subject.
Might need different insurance.
Yeah, you would need different insurance. What I'm trying to get to is I don't offend anyone, and if I do, I humbly apologize. Do you know, for me, where the problems lie is not the children, it's the spouses of the children. They're the ones who are causing problems. Because even if the children want to follow a law, they will go on the law of the country because the law of the country is different to Islamic law. This is why I told you, is that when it comes to Islamic law versus conventional, conventional doesn't make it Islamic. Islamic makes it Islamic, but conventional is different. I'm going to go through bullet points. How much can you make a will for according to Islamic law? This is a very authentic hadith. You only have up to 1/3. So if you look, you have £100, only £33, 33 pence is in your control. 66.67 has to go as per Islamic law. But in this country, you do what you like with your £100. That's why I told you, because of the law of the land, make it right. Because of the law of the land allowing you, it doesn't make it right. So as a will is 1/3. You're looking at 100%, but as a will, according to Islamic law, is 1/3. Conventional law, you can leave all your money to the cats and dogs home. That's up to you. But it doesn't mean it's right. This took me time to find. You know, it's such an important fact that the disappearance of inheritance is the first branch of knowledge to disappear within the Muslim community. This is why so many Muslims come to me and they're clueless what are the shares, who gets what. And when I found this text, and please, I'm not going to back it up with any authentic narration or whatever. But this, I can put my hands on my heart and say that inheritance is one of the first branches of knowledge people will forget, because this is something people doesn't know. If you go to Surah Nisa, verses 11 to 14, the inheritance laws is black and white. It's 11 to 14 and verse 176. So this goes back to the first slide, or the previous slide, that knowledge is very important and it will be taken away from his ummah. If any of you want any of the slides, and I'll be giving some free literature, a free template, you can scan this. I can give you my business card, send me a WhatsApp or an email, and I'll gladly send you all the documents. Now, this is the laws of intestacy. I'm sorry, it's quite small. Sorry. I will be giving you 4 documents. You have the presentation, letter of wishes, a template for the will, and an inventory where you can write down what you own. And I'm going to tell you the importance of these documents in a moment. So if you want to take this, send me your details. I'll gladly send you the templates. But my business card is here as well, and I'll share this with you as well afterwards, inshallah. Laws of intestacy. It's very small, I'm sorry. Basically, in European law, and it's really upsetting, that your spouse and their children are the legal heirs. I'll say that again. According to UK and European law, your spouse and your children are legal heirs. Your parents are not legal heirs. So if you have 100 shares, what does Islamic law state? Your mother and father will take 1/6 each. I'll say that again. You have 100 shares. Your mother and father, if they're alive, will take 16.66 each. The wife takes 12.5, and the balance 2 shares to the son, 1 share to the daughter. I'd even mention the brother. I didn't mention the sister. They're not legal heirs because the father's alive. If the father's alive, is blocking the siblings. So you have 100 shares or £100. I think shares sounds better because it will be difficult to calculate. But out of the 100 shares, 16.66 to each parent. The wife takes 12.5, balance 2 shares to the son, 1 share to the daughter. If the wife passes away, the husband takes 25 shares. So the wife took 12.5, husband is double 25. Her parents, the wife's parents, will take 16.66 each, and the balance 2 shares to the son, 1 share to the daughter. Now many people say, I've put the property in my wife's name. I say, well, you better make sure you keep good relations with your in-laws, because according to Islamic law, they are legal heirs as well. I'm going to keep going back to the point. If conventional law allows something to pass, doesn't make it Islamic. So this is why, don't mind me saying why I put the disclaimer in, is that if you are receiving money knowing according to Islamic law is not your share, but the law of the country allow it, for me this is wrong. Now I'm not going to issue any ruling, any fatwa, that's not my job. But if you ask me, it's wrong. But in reality, what is going on, it's not fair, it's not right. Families are fighting, and obviously once it goes to the legal system, you'll be there for a very long time. And the legal fees in some cases could equal the inheritance or even more. And we haven't even touched on inheritance tax. The laws of intestacy, thank you. This actually tell you who gets what according to the English law. But like I said, this is not Islamic. And if you look here, the first tier level, so if you look here, the wife, okay, you have children, yes. If you have children, the parents are not legal heirs. Let me just give you an example. I do a lot of work in Dubai, in United Arab Emirates, in the Gulf. We have an office there. I deal with a lot of the will's probate inheritance there. When I speak to the non-Muslim and tell them that your mother and father's a legal heir, they get shocked. They said, what? According to Islamic law, my parents are legal heirs? I said, yes. You know what they're telling me? This is a very good system. They're telling me, but unfortunately, the Muslims themselves are not happy with it. Because the law of the country doesn't allow the parents to get a penny, doesn't mean it is right. Now I'm going to come to you why parents are legal heirs. The women, sisters might be thinking, 12.5%? Wait a minute, it's not a lot, is it? 12.5%. You know, when I sit down and talk to people, I speak to a lot of non-Muslims as well. And people, non-Muslims are asking me, why can't the Islamic law change? The world is changing so much. Why can't Islamic law change? I say, look, this law is written into stone 1400 years ago. It's not going to change. People can change. And when we talk about all the problems, especially in this part of the world, certain words I cannot say for obvious reasons, but if you look here, with the gender crisis going on, are you going to tell me Islamic law should change? Because the gender, or people don't even know what gender they are, so it's okay to change the Islamic law. Islamic law is not going to change. It's written in stone. These are man-made laws. This is why it's going to fail. But the point I'm trying to get to is when I speak to the non-Muslim and tell them, your mother and father who raised you, clothed you, fed you, they should have a slice of the cake. They said, you're right. They should get it. Now, if you take India, for example, according to the law of India, if the husband passes away, the wife, the children, and the mother are legal heirs. The father is not a legal heir. So in India, the difference between Indian law, obviously in Pakistan, they have Sharia. That's a different matter. You look at India, the father's not a legal heir. The mother's a legal heir. I know non-Muslim people, solicitors in India, challenging the government, why is the father not a legal heir? This is a non-Muslim doing it. In this country, your parents are not legal heirs. I know many people know you can gift your property to your children. You know that, you can gift in your lifetime. This table I've prepared is called a taper relief, that if you gift and you got to live 7 years, but if you pass away within the 7 years, that's what you pay. This is what tax you pay. So I know some people say, why don't we gift during our lifetime? You know, when I was coming here, I wasn't sure about the TV and connecting the laptop, because when I do talks, I just hold a piece of paper and I go through the points. But when you've got this set up, I was very impressed. So I had to push all those points into the presentation. So bear with me. I know some of the slides may be mismatched, but I just want you to understand, this is the Quranic evidence on the shares. People question me, where does it say in the Quran who gets what? Surah Nisa, verses 11 to 14. And obviously, when people think that they will not die, I have to refer to Surah Imran, verse 185. So brother, you're going to pass away. No one's going to take the money to the grave. But it's funny, because sometimes I have to explain it to the Muslims as well. You are going to pass away. It's written in the Quran. Like I said to you, you only have 1/3 of your estate. This is the authentic hadith that confirms you only can make a will of 1/3. But like I said, in this country is different. What I'm telling you is what Islam allows you to do. Now, what is the objective of the 1/3? Many people think charity starts from home. I agree. So if you have money you want to give into charity, giving it to members in your family, you can. But you cannot give it to a legal heir. Your wife is taking 12.5%. Your parents are taking 1/6 each. You can't give the 1/3 back to them. According to the authentic hadith, it should be really for charitable reasons. We all believe as Muslims, when we pass away, our book is closed. If you have children making dua, you get the sawab for it. If you have your good deeds you've done in your lifetime, inshallah you will get the sawab for it. But I just took it a step further. If you couldn't do good deeds in your life, Allahu Alam, that's between you and your maker. You don't have children, or your children are not going to actually do any good deeds for you. This is where you have one last chance of making the will of up to 1/3. That's why you have the letter of wishes, because in the letter of wishes you can tell your trustees, use the 1/3 for XYZ. You can build a masjid. Countries like the Philippines, where Islam is increasing, you won't believe it, they have a shortage of masjids. Go to Kenya, there are shortage of water. This is the 1/3 you have. So I say to everyone, the will is your last chance. In the will is the last chance you have to do some charity, because when you're gone, everything has to be liquidated. All your money, all your debts and liabilities will have to be settled. Whatever net money you have is called in. Out of that, up to one, not saying the full 1/3, up to 1/3, you can give this to, or give any amount to charity. But you cannot give the charity back to a legal heir. And I'm sorry to say there are difference of schools of thoughts that they say you can do it. So the wife is taking 12.5%, I'm going to give her 1/3. This is wrong. I don't want to go into the different schools of thoughts because it will open a can of worms. This statistic is wrong. It's not 2 out of every 3 people. I'll say it's 3 out of every 3 people do not have a will. People don't want to talk about it. And if you even have a will, I guarantee it's probably out of date. Or to complicate matters further, I bet you don't know where you've put it. That's another problem. So when you're dealing with a death case, where's the will? Have you got a will? Is it in line with your wishes? So for me, a will is a legal binding document that coordinates your wishes after your death. Now, why am I saying after your death? Because if you are in a coma, if you're breathing oxygen, you are still alive. If the doctors declared you 99.99% dead, but you breathe in oxygen, you're still alive. For a will to work, you need a death certificate. No death certificate, no will. A will allows you to communicate your wishes clearly and precisely, including appointing guardians. This is something everyone overlooks. If you and your wife are no more, and you have if you and your wife are no more, who's going to look after your children? People only think about will for money. I say, wait a minute, your children, who's going to look after them? Unlike a trust or a holding company, a will is only activated upon your passing away, and it can be revoked or amended any time. For us, a will is one of the most important documents ever drafted in your lifetime, and our job is to make it as easy as possible. So, what happens if you pass away with no will? Local laws apply to the distribution of your estate, which is based on the laws of intestacy. If your parents are alive, they're not considered legal heirs. I'm not saying this, it's the law of the country. All your end of service benefits, life assurance, whatever it is blocked. All your other investments, including if you buy any property or you're in the process of buying a property, that's blocked. The court can appoint an executor. Now remember, what is an executor? An executor is like a PRO dealing with the paperwork. Court will appoint the executor. I guarantee you when your family's fighting, who's the first person to go to court to inform the court, start the work? That is the role of the executor. Family arguments will arise. I'm of the belief money wakes up the devil in the person. It's not rocket science. So when you don't have a will, families fighting, you're stuck. Inheritance tax of 40% will apply. Not between spouses, your parents and children. So let's think for a moment. You make a will to your wife, which many people do. You save on the IHT. But does that mean it's her money? Or if the wife make a will to the husband, he gets all the inheritance, there's no tax. Does it mean he keeps all the money? The answer is no. Okay, the law of the land applies it, but it's not his. You probably drafted the will in that fashion to save on IHT. Everyone does it. Who wants to pay 40% tax to the government? Nobody wants to do it. Assets in other countries would be distributed according to the laws there. Every country has a default law. If you go to Pakistan, it's Sharia. If you go to a country like India, your father is not a legal heir, but your wife and children get the money equally. If you go to the United Arab Emirates, they apply either Sharia law or they've got a new law there which is based on the European principles, 50% to the spouse, 50% to the children. Funeral arrangements. You know, I had a case where a Filipino became a Muslim. She was a Christian turned Muslim. She took the Shahada. 2 weeks afterwards, she died of a heart attack. You know, her parents came and cremated her. They wouldn't bury her. You know why? She didn't make a will. So you're thinking, wait a minute, you need a will even for your funeral arrangements? The answer is yes. Do you know, in this country, organ donation, they'll do it anyway, whether you like it or not. So even filling in the donor card or not, having a will, letter of wishes, all your paperwork's got to be in order so that even your organs are protected. Children's control of the inheritance. Now remember, you know the 2 shares to the son, 1 share to the daughter? Who controls that money? Till they reach the age of maturity. Age of maturity is also another debate. Because according to the UK law, age of maturity is 18. Now you imagine you give £100,000 to an 18-year-old. What do you think they're going to do? It is a very expensive process and time-consuming dealing with all the red tape. And imagine the businesses you own. Who's going to deal with the business shares? How's the money going to be apportioned? Who's getting what? If you have a registered will, it will expedite the distribution of your estate. Your wishes will be honored here. The will covers your estate and life policies, but complete the beneficiary forms. I'll touch on that in a moment. All your investments will go to the right people. So let's say you're holding something in your name, but it's not yours. It's in your name, but it doesn't belong to you. Even that has to be returned to the rightful owner. That's an obligation on you. But you know what happened? It's in your name, you pass away, you will everything to your family, they get the estate. And the person who's the rightful owner is going to the court. Good luck. No family disputes. You know what's it like reading out a will in a boardroom where you got all the legal heirs? Maybe they won't agree, but having the will, which is signed, registered, believe me, that document holds a lot of value. If you are going through a divorce, you can block your ex-partner. This is something very important. It's a very cost-effective process dealing with execution. If you have children from a previous marriage, they are legal heirs as well. Remember I said 2 shares to the son, 1 share to the daughter. Even if you have children from a previous relationship, they are also your legal heirs. You can't deprive them of the inheritance. You can leave a gift of money to a family member or a charity, like I said, up to 1/3. Nominating an executor is very important. You might know your family is going to fight after your death. You know they are going to cause problems. So what you can do, appoint someone else to run the show. This could be a professional. It could be a trustee of the masjid. Someone who can go say, wait a minute, I'm following the wishes of the deceased. I'm not here to deal with your arguments. That is the job of the executor. But for me, another reason why having a will is important is appointing guardians. Now, I try to study the Islamic law, trying to go as much as I can, that who's the rightful guardian of the children if both the parents pass away. And when I was reading the text, there were different people depending on the circumstances. My argument is you as a parent should know who's the best person to raise your children if you're no more. If you are no more, you have young children, who is the best person? You should know. Don't let the courts decide. Don't let the family fight. We all say the wife's mother, the mother's sister is like a second mother. So this is where I say, if there is a relationship, like the children knows their khala very well. Not khala, what's it? Khala, yeah, sorry. Yeah. Then write her name down as the guardian. But you might think, I can't expect my wife's sister to be going to the courts, paying the debts and liabilities, transferring the property. I'd rather get my brother to become the executor. So look at the difference. Executor is the person dealing with the paperwork, where the guardian is raising the children. I'm not talking about the inheritance. Inheritance, good luck to you what you do. I'm just talking about who's looking after your children. Who's going to deal with the execution? Guardianship is very important. Now, the age of maturity I told you is 18. That's another debate I'm going to come to in a moment. So why draft a will? It protects your children, the guardianship. For me, children are more important. People only think about their property. I know property assets, it's important. But if you have minor children, they're also important. And ensuring your estates are distributed correctly, hopefully according to Islamic law. Power of attorney. I told you a will only works when there is a death certificate. Let's say you're brain dead, incapacitated, or in a coma. Can a will work? Yes? No? You're right, no. Why? There's no death certificate. Whether it's the UK, whether it's the United Arab Emirates, whether it's India, Pakistan, Bangladesh, it makes no difference. Without a death certificate, a will cannot work. That's why you have a power of attorney. But please note, there is no such thing as a global power of attorney. The power of attorney has to be registered in the jurisdiction where you intend to use it. Now, when it comes to drafting a will, these are the housekeeping tips I give to people. And you need to follow this. With a will, you have a power of attorney. You have a letter of wishes. Letter of wishes deals with informal requests. For example, where's that 1/3 going? Let's say you want someone to do Hajj. Let's say you want to build a masjid, you want to build a well. Put in a letter of wishes. You can keep changing, updating this every time. Make sure you give this to someone. What's the point of you preparing one and you're not sharing it? We have a template, I can give it to you. Even in this template, I'm talking about jewelry. Now, technically, if you look at jewelry, that's part of your inheritance. I was reading the Islamic texts. Do you know if you have a cardamom in your pocket? A cardamom. I mean, who thinks of a cardamom? A cardamom piece in your pocket is part of your inheritance. So don't think jewelry is excluded. However, if you have jewelry and the legal heirs are happy that you're saying this goes to daughter 1, daughter 2, daughter-in-law to be, letter of wishes. Always complete the beneficiary forms where you work in. If you work for a company that have life insurance, Now let's not talk about life insurance, halal, haram. That's a different debate. It's a very interesting talk. Dying with a debt for me is haram. So if you have a debt, do you take out life insurance or not? I say yes, take it out. Why? Because the debt is on you. But even life insurance, there are different types. So you go for a particular one, but that's a separate talk. If you're working for a company and they're giving you group life insurance, they should give you a beneficiary form that if you know more, where does that money go? Do you know if you don't complete that form, that money will go in your estate, increasing the inheritance tax? So let's say you get £500,000, example. That's taking over you the threshold. So you imagine you add that £500,000 to your house, your bank accounts, whatever you have, you're going to end up paying 40% tax. Assets. What do you own? Have you told anyone? You'd be surprised, husband don't even tell the wife where the money is. Sorry? Funeral arrangements. Do you know repatriation is, it's wrong. I know people who've passed away, they say we're burying the body back in our home country, our Islamic country. I'm sorry, it's wrong. Because to transport a body, when there's a Muslim graveyard here, you have to embalm the body. Does anyone know how embalming works? Yeah, well, I tell you what, you know, yeah? Just watch a YouTube video. They tell you how they embalm a body for a long haul flight back to your home country, because this is my home country. This is my Islamic country. I want to be buried here. You die here, you want the body buried there. This is wrong. I'm sorry. It's 100% wrong. And people should take this subcontinent mentality out. If you go to Florida, Orlando, Disney World, you have a holiday and you're no more there, then one can argue, okay, let's fly the body back. But here, come, there's so many Muslim graveyards here. What is your problem? Funeral arrangements. This is part of the letter wishes, part of the will. You need to be buried immediately near to a Muslim graveyard. Life assurance is a double-edged sword. I'm of the opinion, if you have a debt, taking out protection to cover the debt rather than moving that debt to your partner, that is wrong. Because at the end of the day, you'll know more. Even the property transfer, even the bank says no problem. We've got the property as security. The property can go to the wife for IHT purposes. The debt is still there. The debt is on the deceased. So we can argue now, why you got the mortgage? Stay in rented accommodation. But if you got a mortgage, this is my opinion, take out term assurance. Term means a specified term for X amount, and if you pass away within that term, the debt is cleared. And if you clear the mortgage, the life insurance finishes, that's it. This is my opinion. What makes the life insurance questionable is that where does the money go if you have an investment part of the contributions you're making? I'm not passing any ruling here. This is just my opinion that dying with a debt is wrong. Either don't get into debt, but if you're going to get into a debt, especially a mortgage, then take out term cover. Bank accounts is very important. You set it up. You have your joint accounts. I recommend parallel single accounts for everyone. And if you have children, open up bank accounts for your children. Because when it comes to dividing the estate, you need to pay the money to the beneficiaries. And in some cases, if you don't open the account, you can't transfer the money. So while you're alive, in the right frame of mind, go and open the bank accounts. Information required to draft a will. It's very simple. I always just request your legal name. But you know, especially within the subcontinent, we say our name is X. but it's Y in the passport. I'm not interested in X, I want Y. So if you're booking a ticket, going on holiday, you need your passport name. I need the passport name, so give me the passport copy. Who are the guardians of your children? Who are the executors and trustee? What's the difference between a trustee and an executor? Trustee is a person looking after the money for the beneficiary, if there's a beneficiary is a minor. The executor is dealing with the paperwork, closing the bank accounts, clearing the loans, transferring the property, dealing with the court, the probate office. That's the executor. Trustee is looking after the money. And how do you want your estate to be distributed? That's up to you. That's what form part of the will. Now these are the questions I usually read out if I'm not doing a PowerPoint presentation. Some of this may be repetitive, I apologize. So, clarity on your, why draft a will? Clarity on your wishes. Avoid family arguments. Jurisdiction. Do you want a global will or a UK will? You want a will separate for India, separate for Pakistan, for the United Arab Emirates? You can make the will separately. You can decide on who are the executors. If you have children from another marriage, you can put this into the will. Guardianship for your minor children is in the will. Avoid inheritance tax. And let me tell you one thing. Between husband and wife, there is no inheritance tax. That's why I told you, even the law of the country allows it. Does it make it Islamically right? That's a question mark. So you can say, I'm giving everything to my wife, so there is no tax. But when your wife received the 100 shares, the question is, you have children. Your parents are alive. What does she do? Does everyone ever wonder why is the split in the family? Why not to one person? Does anyone, I mean, I've asked this question. Why can't you will everything to your wife? Why can't the wife will everything to the husband? This is my opinion. A, you can't have a monopoly.
If she remarries again,
Thank you. That is the main point. Second marriages are very common. Too common. This is how, when I speak to non-Muslims, I tell them about the Islamic law of inheritance, they understand it. If you look at the death cases, I'm seeing cases, parents are living longer. Even me and my brother-in-law, Rahil, we were having a discussion coming here. Parents are living longer. Children are dying first. If you look at the percentage of people living longer, it's increasing. And if you look at the middle-aged people who are dying, that's increasing. So for me, where the parents are putting the children to rest, to me is going against the laws of nature. But you know what? It's a fact. I deal with so many death cases, and when I look, the father's still alive, son has gone first. I see the mother alive, the daughter's gone. And I can't even imagine, how's the parent thinking that it should be my time? How come my children's gone before me? I never wish this upon anyone, but it's happening. If the husband wills everything to the wife, and the husband is no more, the wife has every right to get married. After completing the period, she's free to marry. Now you imagine your money you're giving to her, she gets married, it goes to another man. How would you feel? Well, you're dead, you can't say anything. If the wife passed away, I guarantee the husband will be with another woman within 1 month, 2 months. In fact, people say forget 1 or 2 months, give them 3 days. So you imagine for the women willing everything to the husband, she's gone, husband gets the money, he's with another woman within 3 days. I'm sorry, the money will be going to the second wife. Do you know who the losers are? Very clever. Children are always the losers. And do you know, if you look at Surah Nisa, parents, well, and the parents, yes, spot on, yeah. They say, even talk about orphans, that when the father passes away, the children are orphans. you need to look after their money. Everything's written in the Quran, but we just take it lightly. And as I'm learning more and more about inheritance, and I'm making reference to certain ayahs or hadiths, it's black and white to me. The shares are fixed. If the UK system is not allowing this to be part of the laws of intestacy, then it doesn't mean what you do is right or what they do is right. You need to document everything. This is why it's important you put everything into the will itself. So what is and why a power of attorney? I'm giving you the best example, is a very bad example, is the missing Malaysian airline MH370. Do you know when that plane disappeared, do you think the Malaysian government issued the death certificates the following week? Think about it, a plane disappears, 200 plus people have disappeared. Do you think the Malaysian government issued the death certificates? Of course not. According to international law, if a person's missing, presumed dead, there's a waiting time of up to 7 years before you can legally declare them dead. Now, I don't know exactly when the death certificates were issued, but if you are owning businesses, bank balances, how are you going to operate? A will cannot work because there's no death certificate. That's why you need a power of attorney. You know, I was speaking to my doctor, well, he's a medical student doctor, and he told me something very funny. He's saying, you know, people are living longer, and because they're living longer, there's more and more diseases are coming about. One of them is dementia, Alzheimer's, is on the increase. So you imagine if you're forgetting, if you can't remember, a will cannot work. That's how useful a power of attorney is. But remember, a power of attorney is a double-edged sword. Be careful who you're giving it to. Now in the UK, it could be set up that it will only work if you have, it's conditional, it'll work if there's 2 doctors' reports that you're incapacitated, the document works. So there are some safety barriers that it can work, but if you go to other countries, the power of attorney is unconditional. Here it's conditional, other countries is unconditional. But remember, when the person passes away and there's a death certificate, the power of attorney is null and void. If you're using the power of attorney knowing the person has died, this is fraud. If you get caught, you're in a big problem. Power of attorney can be general or specific. For example, you can say, I just want you to manage his property. Or a general is where the attorney, whoever you're given the power of attorney to, so you have the principal making the power of attorney, the attorney who's receiving the power of attorney. You can tell the attorney he can buy, sell, transfer. That's called a general. But a special power of attorney is that you only manage my business. That's it. So there are different types of power of attorneys, but be careful to whom you're giving the power of attorney to. And like I said, the power of attorney will become null and void. Guardianship is important, appointing the right people. Temporary and permanent guardian, what's the difference? Let's say your family is in your home country, just you and your wife and children here. You have no relatives. Then you appoint a temporary guardian to babysit the children. The permanent guardian will come, take the children, go back to the home country. But if you are living here, you have your siblings, your parents, there's no need of temporary guardians. Now, I just go through the rest. Legal capacity test. If a person signing a will, for example, in a hospital, you should have a certificate from a doctor that the person signing the will is in the right frame of mind. This is very important. There's nothing more upsetting when somebody call me and say, can you register a will for my father, he's in the hospital. I ask, what is his state of mind? I don't know. Can he communicate? Can he talk? These are the questions I need to ask. If the answer is no, forget it. You can't do anything. Witnessing of a will. Now remember one thing. It cannot be a legal heir. If you're making a will, you can't get your son to be a witness. Technically, he shouldn't be a blood relative. It's got to be independent. If you follow in the Islamic law, 2 male Muslim men. But I know here it could be any 2 witnesses. But for God's sake, don't make sure they're not a legal heir, not a blood relation. I always recommend get a notary public involved. Because there have been cases where the legal heir is saying, that's not my father's signature. You coerced him to sign it. So get professionals or notary public. Severance, now this is very important. Let's say husband and wife owns a property together. By right of survivorship, if the husband passed away, the wife gets the property. If the wife passed away, the husband gets the property. This is called right of survivorship. Severance is where you cut the property into 2 parts. So the husband can will his 50% to whomever he likes, and the wife can do it. Now, why would you want to do this? Let's say you and your brother owns a property. So 2 brothers own a property. If they haven't completed the severance paperwork, if brother 1 passes away, second brother gets that property. But the brother said, wait a minute, this 50% share of mine should go to my wife and children. But because you did not apply severance, it will go by right of survivorship to the co-owner. So remember, if you have a property in joint names, whether it's husband and wife, whether it's brother and sister, 2 sons, 2 sisters, whatever it is, maybe it's father and son, you need to apply severance so that the share will go to the beneficiary. Another reason when it comes to severance, I've seen cases where people are divorced, but they couldn't sell the property. So ex-partners are owning the property, but they didn't apply severance. So what happened if the male or the husband passed away, the ex-wife will get the property, or if the ex-wife, the wife passed away, the ex-husband get the property. That's why severance is there. One more thing, if you're going to a care home, I don't know if you know how the laws here work. If a parent goes to a care home and he owns a property, the council will take control of your property. Now, if you apply severance, they only can take 50% control. If you apply severance, they only can take control of 50%. If you don't apply severance, they take control of 100%. Missing or last minute legal heirs turning up. I can't tell you how funny this can be. That the husband passed away, you know him, he's married to that woman, there's 2 children. And before you know it, another 3rd child comes and says, it's my father as well. No, it happens. It happens. I feel sorry for the family. They didn't realize there was a sibling all these years. It happens. Especially some people have a wife in country A, a wife in country B, and wife here doesn't know wife there. He passed away, then suddenly the wives are now communicating. This do happen. And for your information, that 12.5% is split 2 ways between 2 wives. They get 1/16 each. Calculating the shares is very, very important. To calculate the shares, you need to know who the legal heirs are. A disaster clause is, God forbid, everything's God forbid, if the family pass away in a freak accident. Aeroplane accident, husband, wife and children all pass away, disaster clause is applied. You know, according to Islamic law, the disaster clause is already built in to the shares. That's when the brothers and sisters, cousins will get involved. Inventory. Keeping a list of assets is very important. People doesn't do it. Do you know in the UK, if you don't claim your inheritance within 5 years, it goes to the government? I'll say that again. Person pass away, you're dealing with the assets that you know of, assets you don't know, after 5 years it goes to the government. You don't make a will, you pay 40% tax. You don't claim the money in 5 years, the government take it. Currently in the banks alone, there is over £14 billion unclaimed money. That is just the bank accounts. I'm not talking about the pension funds and everything else. I hate to think what is happening in countries like UAE, India, Pakistan, Bangladesh, Switzerland, Singapore. I hate to, just trying to imagine how much money is sitting there unclaimed. Making an inventory is your job. When I draft a will, I'm not going to write down you're working for this company, you drive this car, you got a bank account here, you got a property here. I say everything. But what is everything? Define everything. In reality, the wife doesn't even know the PIN number of the mobile phone, doesn't know the PIN number of the credit card or the debit card, because you kept too many secrets. On the other hand, many men are telling me if one wife knows where the money is, she will probably end up taking all that money and divorcing me. It's a double-edged sword. Even when the wife's telling me, I'm not telling my husband where the money is, he'd probably poison me and marry another woman. It's possible. Money wakes up the shaitan in the person. That's why preparing an inventory is your job. But it's only preparing, it's sharing and updating that inventory. We have a 45-page document I can give to you, but I don't want it back. This is for you to keep. Share it, but please update it and give it to someone. There's nothing more upsetting. The person has died, you got the will, but you don't know where the money is. And this is a fact. This is a problem in every country in the world. Differences between Sharia and conventional law. Let me tell you one thing. Everyone in the family gets a slice of the cake. Your mother and father who raised you, clothed you, fed you, sacrificed you for you, they're getting 1/6. Now they don't need the money, that's up to them. They can say let it go back to the family. But the law's not going to change. And one thing I like about the Islamic law of inheritance is that if you are following the law, there is no arguments. Everyone knows what they're going to get. So you don't need to start checking this law, that law, who's getting what. You know this is your share. You like it or don't like it is a different matter. Why do sons take 2 shares, daughters take 1 share? I question this a lot. I came to my interpretation. It's the son's responsibility to look after the mother. Now, if in reality they don't do it, that's their loss. They will be accountable. It's the son's responsibility to look after the sister, to get her married, to pay for her education. So when people say to me, 2 shares to the son, he's getting too much, I say, wait a minute. Once he pays for the sister's education and he's working, trying to look after his mother, he's not even getting 1 share. But what the daughter gets, 1 share, that's her fixed deposit account. You can't even take the money from her. You can't ask for that money. That is a fixed deposit account. So for the daughter, what's mine is mine, and what you got is your job to feed me, clothe me, and education, and get me married. That's the essence of our law. But in reality, when the son takes 2 shares, Khudafiz gone, emigrates. And then the son is telling the mother, thank you, goodbye, I'm married. I'm not living here, I'm off. This is where the problems are. But you know what? Islamic law is not going to change. People, we have to change. Islamic law will never change. And now it comes to another question. If the parents are no more, how's the money split? The wife still takes 12.5%. The balance, 2 shares to the son, 1 share to the daughter. Even the siblings, the uncles and the aunts and the cousins are not involved. The siblings only get involved where there's no male inheritor. So if the husband passed away, has a wife and 2 daughters, and siblings, do you know the daughter's shares is now 2/3? So imagine 2 shares to the son, 1 share to the daughter, no son, no father, no grandfather. The daughter's shares has gone to 66.66%. The wife's share is 12.5%. The balance of about 21% goes to the siblings. 2 shares to the brother, 1 share to the daughter. But there's something very important you need to understand. When you are dividing up the inheritance, if one legal heir passes away, you have to open up another inheritance for that person. Example. Husband passed away. His parents are alive. They're taking 1/6 each. But before they can take the 1/6, the grandfather dies. So now you've got to open up a separate inheritance for the 1/6 to look who are the legal heirs there. That's why when you're dealing with these cases, you need to be very careful that if one of the legal heirs pass away, it's not a case the money goes back into the pot. No, you've got to open up a separate legal heir case for that person. And whoever their legal heirs are, that money goes to their beneficiaries. Joint tenants versus tenants in common. This is a very important point. Joint tenants mean if you have a joint bank account or a joint property, by right of survivorship, the shares automatically go to the next person. Tenants in common is where you apply the severance and each person has 50%. Then you will it accordingly then. So, the £1 million question. If you have a joint property, husband and wife, and the husband passes away, does it mean the wife takes the full 100% or vice versa? This is a question, I'm sorry, I cannot even answer. You know why? Because when it comes to the principal residence, there is no mention in this in any of the Islamic text. I'm talking about the principal residence. Otherwise, I've seen cases where the legal heirs come in and tell the widow, sell the property, we want our money. So imagine in the case where the siblings come because there were no sons, the siblings are telling the sister-in-law, sell the property, we want our 20%. And then the sister-in-law, the widow, selling a property to pay their money back, and she's forced to live in a smaller property because she cannot afford. I can't answer this question. Because for me, technically the wife, the widow, should keep the property, but if the siblings has a claim, it's their choice. If they want to waive that share, say you keep it, it's up to them. So when it comes to joint tenants versus tenants in common, it is a very sticky, it's a very emotional subject. Because I also believe each person will be judged accordingly, separately. So for me, tenants in common make sense because you're going to answer for your actions. But this is just my opinion. Life assurance. Now, I told you it's a very delicate subject. For me, if you're looking at 2 wrongs, I'll go for the lesser wrong. So if you've got a debt, then take out life assurance. Otherwise, the debt is on you.
What's the implication of dying?
Can you speak up?
What's the implication of dying with debt?
What's the implication of?
Dying with debt.
Our Prophet, peace and blessings be upon him, wouldn't even lead the janazah until the debt is cleared. This is not I'm saying it, this is in the text. So when there were people who passed away, yes sister, please.
So questioning in cover doesn't start until your debt is paid off.
When I was looking into this topic, I was reading back on the text. Our Prophet, peace and blessing be upon him, he will, at the time of any of the people passing away, will say, go and inquire if there are any debts or liabilities on this deceased. So the Sahabas will go check, come back and say, no debt. He said, okay, I'll lead the janazah. There was a case where they said there was a debt. He said, I can't do it. Clear the debt first. The person's not even buried yet. So going back to the question, you have a property, you've got a mortgage. Now we can debate. I'm assuming the mortgage is halal, but that's another different debate. But there's a debt of, say, £500,000 at the bank. What do you want to do? You're going to try and sell the property? For me, take out term assurance, which is the most cost-effective cover you can get on the market. There's no savings, no investment. You pay, if you don't die, you don't get a penny back. Again, I'm going for the lesser.
Can I just ask you, so on this term insurance...
Yes, I don't sell life insurance, by the way.
I know.
Okay.
But it's because I was questioning my own accountant on this, who's also quite, they're huffies and stuff like that. So I was asking them, because they deal with this on a daily basis, because they have many clients. So they said that basically they also recommend, if you have a debt, to take out the term insurance.
Thank you.
But say, for example, because you're talking about a debt in the future, you're taking out a term insurance now for what debt you might. So, for example, like you said, $500,000, for example, but you don't know when you're going to die. So, for example, if that debt is paid off before you die,
Cancel the policy.
the policy is null and void.
That's right.
However, if you die and then the amount left to pay the bank, as it were, from the 500 is reduced down to 200, for example, yet you've taken a policy
Or 500, yeah.
right? Then
There's a surplus of 300.
Yes, you've got surplus here, so you can then specify in your letter of wishes that this extra...
That's the beneficiary form.
Yeah.
That you see, when you take out a life insurance, you have to assign it to the bank.
Yeah.
So if you pass away, the 500 goes to the bank. Bank will clear the mortgage.
Yeah.
Now, if there is a surplus, they need the grant of probate issued by the court, who are the legal heirs. So the money is going to the bank. Bank will clear the money, clear the debt, update the land department that the debt is cleared, take the charge off the property. If there's a surplus amount, they say, right, get us the grant of probate, then we know to whom the payment should be made to.
What was advised to me,
Please tell me.
right, was that any surplus you have left over,
Yeah.
you've taken out that policy based on your intention not having any debt on your death, or using it to pay the debt on your death. Any surplus should not benefit the heirs of your
Yeah.
under this family,
yeah.
and that should be given out on charity basis. Or
That's another good way of looking at it.
Your wife, your parents, whoever's left that would normally inherit under Sharia law.
You know, like I said to you, the best type of will is when you sit down with your family and explain everything. Put all your cards on the table. I know in reality it doesn't happen. It's because there's so much animosity in the family in the first place that you're trying to tell your children, this is what I want or what is. But what I like about Islamic law is the 2 shares to the son, 1 share to the daughter. You don't argue with it. Even you're trying to justify it, you say, look, it's not me, it's our creator. You're going to question the creator. And somebody say to me, like in Dubai, where they follow the Sharia principles, somebody say, I want to give everything to my wife, make a will. I said, you want me to change the Sharia law? I can't do that. If the wife shares 12.5%, I can't change the law. So, you know, this is one thing good. The fact is, the shares are written. But why are there so many disputes? It's because the law of the country allows you to take more than that 12.5%. So life insurance. But you know something also you can look into is key man insurance. I know this is, again, it's probably opening a can of worms, but I've seen cases where the business have to fold. Why? Because the person has died, who's going to run the business? And the business partners are fighting. So there is something called key man insurance, but it is a very thin line on the example you gave to me where there's a surplus. What do you do with it? Letter wishes. We have a template for you. Remember one thing, it's not legally binding. But if you want, again, this is for everyone, organ donation, that's up to you. Put in a letter of wishes. If you don't want organ donation, put it in there. You can mention your debts and liabilities. So it's like a document you can keep, like a spreadsheet, you can keep updating it, write everything down. What you owe, who owes you, what you owe to someone else. Share the copies with the family, always keep destroying the old ones. Religious liabilities, maybe you never did Hajj, you never had the chance. Maybe due to XYZ reasons, you couldn't do it. Then letter wishes, out of that 1/3, you remember, so you can give it to charity. Out of that 1/3, tell someone, do Hajj for me. I couldn't do it in my lifetime. Religious liabilities could be prayers you missed, fasts you never kept for whatever reason. All of that can be documented. Jewelry, avoid arguments. You can say, I want this going here, this going there, and so forth. Any payments, charity loans, sponsoring a child. This is very important. If any of you are sponsoring a child, you want this to continue after your death. Letter of wishes. For me, repatriation of body is not allowed. But sometimes people have a preference. Maybe they bought a plot of land at a particular graveyard. Write it down. There was one person in Dubai. He lived from Canada. He bought 8 plots. He never even told his children to bury me there. But he bought the plots, but he never told anyone. So I said to him, when you're dead tomorrow, how are your children going to know where you should be buried? Children's education. This is really important. There could be some personal preference where you want your children to be educated. Is it letter wishes? We say it's from the heart. Personal requests. You don't put this in the will. Why? Because then you'd be updating the will every 3 months. Funeral arrangements. We put it in a will separately. That's up to you. Maybe you've got a prepaid plan. Mention it. Age of maturity. You know, to me, age of maturity should be minimum 25. Absolute minimum. Many Europeans come to me and say, we want 30. You're mad. I'm not trusting my son or daughter with £100,000 at 25. But in this country, age of maturity is 18. I heard a rumor they're trying to fight the system to change it to 16. That's ridiculous. But do you know when drafting a will, you can write down what age you want your children to inherit the money. That's why the will is required. Even you're following the 2-to-1 shares. What age you want them to inherit. That's why you have the executor, the trustee of the will. And sorry if I do sound sexist here, but I feel like girls mature faster than boys. So a 21-year-old boy in university who's still playing PlayStation, give him 100 grand versus giving it to a female, probability, I think the female will invest that money wisely or look after it. But for me, age of maturity should be 25. Beneficiary nominee form is important you get them completed. If you're working for a company, ask your HR department to give you a copy of that form. Get it completed. Because if you are in HR and one of the employees pass away, you look for the beneficiary form. If there's no beneficiary form, you have to freeze that money, wait for the court order. And 10 out of 10 cases, that money goes in your estate, increase in the inheritance tax bill. Now, there's a fundamental difference between a beneficiary and a nominee. Does anyone know the difference? The difference between a beneficiary and a nominee. There's a very fine line difference. A nominee makes the person mentioned a caretaker. A beneficiary gets the money. So when people say I've completed, especially in India and Pakistan, they have this beneficiary nominee system. They keep saying nominee, or beneficiary I should say, but it's actually a nominee form, which means post-death, that form you completed doesn't make that person the actual beneficiary, only a caretaker. The will state who the beneficiaries are. Document attestation. If you're holding assets in different countries, is very important. Yes, sister. How's nominee different to? Okay. Power of attorney is a document, a general document you draft. You're the principal. Say you make your sister the attorney. She manages your estate. A nominee is where you have a form completed with, say, the bank. where you're saying this person is a caretaker of my money. So I would say power of attorney is a more general document, and it could be set up conditionally or unconditionally, but the nominee is just a caretaker. So technically, if you look at the population of India and Pakistan, you're looking over 2 billion people, probably 1/3 of the world's population. If they start freezing bank accounts in those countries, the court system will collapse. They can't deal with all the court cases. So why they put the forms there? So that post-death, you don't need a court order for that bank account. But the problem is that nominee form is not a beneficiary form. So if one of the legalists come forward to challenge that nominee form, then they will freeze the account. You have to wait for a court order. So many people don't know the nominee form can be challenged. Document attestation is important if you have assets in other countries, like you have an apartment in Dubai. Your marriage certificate should be attested if you want the property to go to your wife. If you want the property to go to your children, the birth certificate should be attested. And the filing system is the inventory that I've actually told you. We have a template for you. We just come into the end of the presentation. We are launching very shortly the Afterlife app in conjunction with Just Wills, where we will act as a document storage company. So hopefully post-death, you will have a platform. All the documents are there to share with the family. The biggest problem for me when I'm dealing with a death case, nobody knows where the will is. No one knows the family members. No one knows where the assets are. No one knows the debts or liabilities. No one knows anything. Even nowadays, you have OTPs come in on your mobile phone. The wife doesn't even know the code to unlock the mobile phone. She doesn't even know how to access internet banking. These are the problems. Will is basically dictating the obvious, that I want the money like this, whether you're following Islamic law or not. Who are the guardians? Who are the executors? Who are the trustees? But when you're dealing with the courts, you need that filing system. That's why you need a copy of the title deed, the bank statement, the logbook for the car. All this document should be kept in a folder like this, and this is what you update. The letter wishes, everything is in this document. If you come to me, I need your help in the court, I need your help, I need this file. Oh, by the way, the will is there as well. That's it, ladies and gentlemen.
But the only time the courts get involved is if someone's challenging the law.
You see, by right of survivorship, majority of the assets will go to the co-owner. So where you need the courts, if it's in your single name or if it's being challenged. And for the sake of argument, and so many disputes going on, you're going to end up in the courts somewhere along the line. So if you have a single bank account in your name, I would say make it joint, because right of survivorship, your wife automatically gets the money, or maybe with your son or daughter. But if it's single, it will be blocked. You need to apply for probate.
So can I just come back to the power of attorney?
Sure. Let's take a seat.
You mentioned on there, you talked about whether you're mentally incapacitated to make a decision or whatever. There are, if I'm not mistaken, there are two types of power of attorney. One being for your medical situation.
You talk about medical power of attorney, and then the financial power of attorney. You're 100% correct. Yes.
They can't be owned under one.
No, it's two. You see here in the UK, a bit similar to the US, is more fine-lined, that you have a power of attorney to deal with the medical care and one for your financial and property matters. Okay, but in other countries it's just one power of attorney, but not a medical one. Because with the medical power of attorney, it gets too complicated.
Just one more question. Sorry.
Sure, yeah, go on, please.
Obviously, using the UK inheritance tax rules, and as you say, obviously there's a lot of problem when you're following the Sharia compliant thing. There is the issue of taxation,
I agree.
tax, and all of that
Agreed.
comes into play. Have they formulated a way forward So, for example, in my case, for example, I'll just give you my example. So, if I die, my will says it goes to the missus so that there's no inheritance tax issues.
You see, remember in the beginning I said, what you receive doesn't necessarily mean
Yeah.
it belongs to you.
Yeah, but can you then put something like in your letter of wishes to say?
That's why it's important.
Yeah.
Like I said to you earlier, it's a good question because I even tell people to say the IHT,
Yeah.
give everything to your wife so you don't pay tax. Fine. But when your wife receives, does it mean it's hers? No. She should be following the Islamic law, and vice versa. If the wife passes away, husband gets all the money, you should be doing the same thing.
Yeah, but can you specify that?
In the letter wishes, you can, but it doesn't make it legally binding.
Right.
So it's a double-edged sword where you will everything to your spouse.
Yeah, but from an Islamic perspective, and I don't know what the outlook is on that. Have you done what's necessary from an Islamic perspective? If, for tax purposes, you've transferred it to your wife, yet on your letter of wishes, you've instructed her, right, to distribute what she's just inherited on an Islamic basis, so i.e. 2-1.
That's right, yeah.
If you've done that part of it, and that's your letter of wishes, and then it's for your executors.
Remember, I also told you the best will is when you sit down with your family and talk to them. So you say to your wife, I'm willing this to you.
Yeah.
Put it in the letter of wishes, but when you get this, it doesn't belong to you.
Yeah.
You make sure my parents get their share. You make sure the children get their share. That's down to her. Now, if you're asking me the question, is she legally binded to do it?
No,
the answer is no.
But from an Islamic perspective,
Should
have I
be.
carried out my
Should.
duty?
Yes.
That's the question.
Look, you've told her verbally. You put it in a letter of wishes.
Yeah.
For me, that is like you've done your part.
At the same time, say for example, my parents who would normally inherit something if I was to go now. So I all went to the wife. She's got the letter of wishes. They're entitled to what was it?
1/6 each.
1/6.
Then how it works, you club all your estate together as 100 shares.
Can they, while I'm alive, can they say, right, in writing or whatever, to say that if this situation occurred where we're entitled to inherit
We don't want a penny.
we want it to go back into the estate.
They can waive their right to the share. It's
No,
not.
not at the time. What I'm saying, can they do that now while I'm alive, while I'm doing
It's a
well?
good question. Look, technically they can do it, but does it make it legally binding? I mean, okay, let's take a step back. Let's say tomorrow they say we were coerced to do it. The will says everything going to the wife, but the parents are saying we were compelled to make this writing. It's up to the wife what she does then. So she's in control because she's getting all the money.
But again, what I'm trying to do here is I'm just trying to ask the question. Where the wife legally inherits it, that's fine. We all
Yeah.
understand that. I'm looking at it from an Islamic perspective, where while I'm alive, I've given the letter of wishes as part of my will to say distributed Islamically, and as it is now, when my parents are still alive, I've done this right now, and as you say, I can update the letter of wishes.
You
while I'm
can't,
alive.
listen, if you're looking at their shares, you can't take that right away from them.
No,
You're
no,
willing
if
everything to
they-
your wife.
Yeah.
If they say today, we don't want the money, give it to writing. Okay, fine.
Then I put that as part of my letter of
That's
wishes.
up to them. But then let's say they come back tomorrow
Yeah.
and say we were compelled to do it. We didn't want to do it. We just want to keep our son happy. That becomes a question mark for me. Technically, the wife
Yeah, but then the
should
wife's
give
still
them.
in control anyway.
I agree, but
Legally,
she should.
the wife is still in
She should
control.
give the money back to them then.
Yeah.
I'm not passing any
Yeah,
sort of
but then
fatwa.
that's for her to-
That's for her to answer then.
Sorry, can I ask just to follow on from that, just a clarification, because there's a lot, I've been to several of these talks, and there's a lot of information which is very good. But the essence was really, Islamically we should do a will, an Islamic will, be in this country or in UAE, maybe they don't have inheritance tax. If we are going to formulate by your company or any other company an Islamic will, according to the Islamic Sharia, as my brother was saying, then really all the elements in there, whether you have a letter of wishes or not, those will be fulfilled. Rights of the shares, etc., regarding your parents. etc.
My-
If you
yeah.
have to write a will by your company, then everything else, the subsidiary like the letter of wishes, are irrelevant.
I'm looking at the will. Forget the letter of wishes. What does the will say?
So the will will say, mum and dad will have their one share.
Fine.
Except
No. Let's go on your argument. Let's go on your point. Then the parents will pay 40% tax.
Yeah.
Children pay 40% tax. The wife doesn't.
Yeah.
Now I'm taking a step back. Let's say give the wife everything. You don't pay 40% of any of the money. But when the wife get it, she say, okay, here's your share. Here's your share. Why is it not Islamic?
I thought you said you can't do it Islamic.
No. 1 second. Think about it. You giving this to your wife, yeah, 100%, and she's giving the money back to the people. They're getting their money. That's it. That's my argument. Do you want to pay the 40% tax? Or you want your wife to get the money, but then she pay them and give their money back? You see, at the end of the day, it's got to be a mutual understanding between both spouses.
Yeah,
That's
how so the practicality. I'm going to do an Islamic will with my wife and a documentation with you, an Islamic will.
Brother, if I don't mind me saying, I'm giving you two options.
Yeah.
You make the Islamic will. Do it. 1/6, 1/6, 12.5%. Do it. But if the brother here is saying, I'm giving my wife 100%, but she's going to give everything, I would say he's also right as well. Because at the end of the day, he's giving the money to the rightful person. Here, the brother here is not paying 40% tax. Your family is paying for it. Which is better? You make that decision. That's why in the beginning I said, I'm not here to pass any law, fatwa, nothing. I'm just trying to, like life insurance. Yeah? People say it's haram. I say, you tell me, dying with a debt is haram. Now, if you take out life insurance to cover the debt, where's it haram? I'm trying to give practical situations. But what you're saying I agree with. I'm not disagreeing with you. I did speak to a sheikh in South Africa, and I gave both your examples. He said, provided they are getting their money. How it went to the wife 100%, went to the parents or the children, so long they're getting the money, that is permissible. At least one side, you're saving 40% tax. I think the brothers want to wrap up now, so.
I just want to make sure this question.
Sorry, I'm sorry, I was so focused there.
Just a small question.
Yeah.
What's the inheritance allowances?
If there's property,
I'm not interested for Islamic law, British law.
anything above £1 million, 40% tax.
Anything above million pounds,
Between husband and wife,
husband and wife.
yes,
If I transfer everything into my wife's name
yes. During your lifetime,
during my lifetime,
then you
that
go,
7-year thing which you just mentioned just now.
yes. Carry on.
I'm quite interested in that. The 7-year, the allowance. You know.
Respectfully, who's going to die first? We don't know.
Well, I mean, from both sides, me and my wife.
Yeah.
7
You
years.
give to your children. Some people are now gifting to the grandchildren to try, because if they reach a certain age in life, they think, what's the point in giving it to the children? I'd rather give to the grandchildren. Chances are they'll outlive everyone. 7-year rule.
I think I will discuss you with that in detail.
Not a problem. Thank you very much. Sorry, sir.
So, very quickly, if there is like a group life insurance policy at work,
Yeah.
and you pass away, the sum being paid from the life insurance policy comes under your assets. Is that
Okay. If you complete the beneficiary form,
yes?
that money goes straight to the beneficiary, bypassing your estate.
Yes.
If you don't have a beneficiary form, HR will say, wait a minute, we need some court document.
Yeah.
Then you have to go for probate. Then you have to include that amount in your estate. You know, that takes you over that threshold. The family has to pay 40%.
Yeah. Sorry, I meant from a Islamic perspective, it counts as part of
You know, is it now a question like the brother here was saying, that this is money that you're not getting or maybe you're not entitled to, then give it to charity then. It's not money you have earned. So, you know, it's which way you look at it is up to you.
Yeah.
I mean, I look at it as a fringe benefit. You're not paying for it, but it's part of the system.
Yeah.
So fill in the beneficiary form. At least the money will go straight to the beneficiary. But what they do with it, that's up to them.
Yes.
Yes, sister.
So you talk about boy having two parents and one, but if you only have a single child, if a husband passes away and there's only one child,
Okay, boy or girl.
boy or girl. So the-
Okay, so say father passed away, you have 100 shares. Wife takes 12 and a half. Parents are alive? No, the son takes the balance. Then 50% to the daughter, 12 and a half to the wife, and then it goes to the husband's siblings, 2 shares to the brother, 1 share to the sister. Okay? Thank you very much.
Just one quick question.
Yes, sir.
Someone of my age, when he came to UK about 55 years ago, he was married. After graduation, he got married, came here. Then he worked for some very rich company director, and then he married her.
Hmm.
He was very rich, all the assets came to him. And then she died, and then he married some other woman,
Hmm.
and had some other children. He had children from the first wife in Pakistan, children from the wife here, and he has huge assets.
Who owns the assets? The
And he has,
husband.
like, set up a trust there in Pakistan. He tried to hide their properties. What is going to happen in that case?
What, the assets here in Pakistan?
Lot of assets, billions of pounds here. He said he had set up a trust in Pakistan.
You have to look at
And
how,
there,
how you set up the trust in Pakistan. You have to look at the laws there. You can look at the trustees and everything is in Pakistan because
there are no laws in Pakistan. You know it very well.
I know it's a sad fact.
Inna lillahi wa inna ilaihi raji'un.
Thank you very much, everyone. Thank you. Assalamu alaikum.